Good afternoon, ladies and gentlemen. So I prepared printouts to cover this class discussion. In this class, we will take an overview about a set of services. The discussion would rather be descriptive without touching on the specific rules as developed by course. So you now see the scope of a topics in projection. How about your vision? Is it okay? In my position, it seems a little feeble. Okay. So as I mentioned in the first class of this term, the WTO now has experiencing extensive renovation from the previous commitment of God. As I said, the scope of jurisdiction expanded actually in wider coverage about a set of goods, set of services, and the contention, international contention issues about a international intellectual property right. So free riding, kind of a international issue was incorporated in some of ambitious scheme of a TRIPS agreement. The set of services in pure ambit of industrialization, you see, is actually representing kind of a most elevated status when we first economy explores the resources. So tertiary industry, the highest level, through the lower manufacturing and also the fishing, agricultural industry, the primary, secondary, and tertiary concept in view of industrialization and national economy. And also, that is the concept now we try in the dimension of international transaction, you see. So the sale of goods still remains mostly the dominant sector in exchanging international business. However, the sales of services gradually increase and now have experienced some fair share against the sale of goods. So the great concern about international trade law and also the national policymakers often see it important that the sale of services is a strategically indispensable and also will need to be promoted to boost the national economy. As you see in printout, the domestic, the dominant fashion of a service industry in the United States were delineated in statistics. You see, very interesting. For example, according to the Department of Commerce, the principal market for U.S. services in Canada, 24 billion, Japan, 30 billion, and the European Union, 96 billion. And also service exports to these three destinations alone accounted for 54% of all U.S. service exports for the year. And in 2002, the United States is the largest producer and exporter of services in the world. And the exports totaled a 255 billion, 17% of the global total. And other second nature countries, as a host country of a export of services from the United States, would include Central and South America, the Pacific Rim, Eastern Europe, and the Middle East. And in 2002, South Africa became the first African country to import more than $1 billion in service from the United States. After deducting service imports, the United States registered a $74 billion service trade plus in terms of service trade surplus. So the United States is a great country to yield many surpluses in trade of service. That is the case in contrast against the sale of goods, export of goods. So often United States is a major country to see a trade deficit in trade of goods. However, the context was perverted. If we see the trade of services, and notwithstanding the international context of service trade, the service industry is a dominant sector in the United States. It explains for a major share of gross domestic product, GDP, what we often call, including, if you see the statistics, if including government, 2/3 of the U.S. GDP were drawn from the service sector. The amount grows to 75% when the private sector is considered private sector GDP is considered by itself. Furthermore, service industries account for nearly 80% of non-farm employment in the United States, specifically 86 million jobs. So now, often the countries across the globe highly trouble with the unemployment problem, and that is also the case for the United States, although we see some improvement in recent years. And we can know the many employers are now engaged in service industry, and so that is the focal point in national strategy to boost. So you have also some details across type of service industries. For example, education, 12 million. Health services, 11 million. Finance, insurance, and real estate, 8 million. And retail trade would account for a 24 million in terms of employment statistics. And entertainment would be a 3 million, and so. So, in total, we see internationally a similar change has taken place. Okay? I mean, the service sector of industry grows, and now it amounts to $1.5 trillion in 2002. So it is actually of great interest that both countries are now endeavored on. So that is the context. The trade of services were negotiated very intensely among the global nations in Bulgaria round, 1987, and we reached the framework agreement, what we call a GATS. It pronounced similar to a GATT, but however you can see, a GATS, a General Agreement on Trade of Services. And it is what transitory nature of agreement to be supplemented with further negotiations. The outcome would be envisaged through the next stage of a negotiation. So Doha round would come into play and expected to play a major role to supplement the specifics of a trade liberalization of service. GATS nonetheless was inaugurated to support the WTO regime and now constitutes a three of major trade agreements in sector and chapters to be managed on a separate council in force. It's the General Council of Trade of Services, General Council of Services, and General Council on Services. Sorry, the General Council means most comprehensive organ. Actually, a most powerful as a standing body to manage the whole of a WTO jurisdiction, and other two councils about trade of goods and the protection of intellectual property. And service trade is also the area of negotiation contended seriously by both groups. What mean a developing and developed country, and that is similar in fashion about mode of a contention and argument, and also some actually antagonistic viewpoint about what is a proper institution to deal with this question, what is substantive justice, and also what does it mean level playing field. So liberal concept and also the kind of a social justice in the international economy now will be seriously investigated and also concerned by both groups, what is often called North and South conflict in a global capitalist economy. So we see later some basics about a WTO agreement involving GATS. You see, in first instance, the need to classify the type of services. It is imposing a difficult questions, and it can be classed into four categories, as you see on page 4 or 4. For example, you may imagine many people from Korean origin travel East Asia, they consume in a foreign country about tourism. So that is one type as encapsulated into four classifications. So services supplied in territory of one party to the consumers of any other. And also a strong aspect of a service provision in the international community now be performed in the first category. Service supplied from the territory of one party to the territory of another. You may purchase some music scores through the e-market. So electronic transaction often involves this type of service provision. So the base of a production and provision of service would be located in another country, and the developed technology may enable to sell via e-trade system. So online transaction, offline transaction, also one concept. Now the Polish makers of international transaction embarked to discuss what is a proper form of taxation. Is it okay to impose tax, impose a tariff rate on a transaction, offline transaction or online transaction? The United States and European nations now almost agree on the non-tariff schedule about a online transaction. However, that comes in a subtle differences when we consider the offline international transactions. And also, what is issue as a threshold matter is to distinguish between the transaction of goods and transaction of services. Often it comes stuck to be denoted, so we would be easy to distinguish between them, since sale of goods involves a tangible aspect, an attribute of the subject matter included in contract. And the service, a subject matter to be intangible and often involves some manpower or labor element, and often involves a scope of a legal point in focus consideration to deal with the question. So suppose if the United States Bank may wish to operate within the Korean territory. How is that? Is it okay? And many statutory regulations may apply to the business entity. And also may require that a natural person may be present to provide services. For example, the legal counsel from United States or Great Britain may reside in Korean territory in their business purpose or a service provision. So we can see the notable point and distinction between goods and a trade of services. So the resources, element, and attributes may differ. And the regulations would include some of a distinct treatment between two types of trade. So the first task that the lawyers need to consider to define the service of trade, trade of services against the trade of goods. And as I've said, often it is easy, but in some cases, put challenges to make it less submissive to any simple notion of classification. Can you help me to close the door? Thank you. Let us report to the first, the last illustration example. You may purchase some of a music scores or records, or in some cases electronic books. It may be seen as a transaction of goods. However, in some cases, labor may be included. For example, order-based the transaction of an art concept, a European automobile, for then they may follow some of a individual basis of a progress in completing their transaction. And the service portion would explain or dominant amount of contract. Then it might be proper to see it a trade of services rather than a trade of goods. So we may see some on ad hoc context to see the nature of a transaction, case by case basis, to in concept and prevailing viewpoint, the attribute of a transaction and the price of each component in contract money, and also the context to process the contractual arrangement, maybe so. And also, you see some of points in frontiering the facilitation of a trade services, which was ambitiously encoded in a framework, GAS. So part 2, for example, relates with the most favored nation obligation. And the concept will differ. However, the fashion to deliberate the legal dealings would converge between two sections of a norms. So most favored nation treatment will also be encouraged to respect involving trade of services. And also transparency requirements were incorporated to guide the, in principle, the trade of services in legal dealings. So the requirements include a publication of all relevant laws and regulations pertaining to providing services by foreign individuals or companies. This is because domestic regulations, other than cross-border rules, would be more imposing and often travels the business person. So it is one of essential concepts. The new WTO regime now requires to make domestic regulations and transparent. It also encompasses with the kind of Western developed legal culture involving a due process clause. So under this requirement, the member states made provisions to be a reasonable and objective and impartial. And provisions need to spell out all such measures of general application should be administered in that fashion. And also the kind of notice requirement may be necessary to satisfy these transparency requirements. And we have a same terms in view of a more favored nation obligations. So each party shall accord immediately and unconditionally to services and service providers of any other member country treatment no less favorable than that it accords to like services and service providers of any other country. So the concept now be shared about like service or like product. The trade policies requires it as a prerequisite to determine to apply the trade regulations and also to define the legal relationship about rights and duties. So For example, the same tariff rate would only be applied to same product, like product. Sorry. And also the regulations and finding a GATS rights and obligations would be presumed on the finding of a like services and so. So different tariff rate may be permissible if the products are not the same. And the term also changing. What is previous GATT provision we see was similar, same or similar merchandise. In new WTO we employ the term like product or like service. And also some distinct point what reserved for the trade of services would cover recognition requirements. So the agreement contains obligations about that point for the purpose of securing authorization, licenses, or certification to provide a service. These types of requirements pertain mostly to professional trade, including legal, engineering, medical, insurance, and accounting. And GATT, as I've said, is a framework agreement, and now incorporates several annexes to detail on a specific sector of a service industries. And Part 3 of GATS contains provisions on market access and national treatment, as listed in the national schedules. National treatment in terms of a service trade would be harsh to harmonize, and also it is often what is cumbersome to impose a uniform fashion of a rule across what difficult and also divergent nature of a service, a trade. So it will be rather challenging when we consider in comparison the transaction of goods. However, also it is one ideal that WTO would emphasize involving a trade of services. So national restrictions on the kind of legal entity or joint venture through which the service is provided, or any foreign capital limitations, must be eliminated. The national treatment provision contains the obligation to the foreign service suppliers and domestic service suppliers in the same manner. Part 4 of the agreement established the basis of progressive liberalization in the service area through successive rounds of negotiations and the development of national schedules. And lastly, Part 5 deals with the institutional issues, for example, establishment of a council of services. So it is transitory in nature. However, the subsequent negotiation will largely be unresponsive to suffice all the prior context of a commitment. So we see little progress when we finish Doha WTO Ministerial 2001. So the context was briefed in box, as you see on page 405. And in your basics, you see some of points delineated to distinguish between transaction of goods and transaction of service on page 402. For example, services are less tangible than products, providing little in terms of samples that can be seen by the potential foreign buyer. Consequently, communicating a service offer is much more difficult than communicating a product offer. Much more attention must be paid to translating the intangibility of a service into tangible and a saleable offer. And also, the business entities of a service provision would encounter some of a financial difficulties, since the bank or financial institution often prefer the transaction of goods, and they often reluctant to invest in service provision. So frequently, even financial institutions with international experience are less willing to provide a financial support for service export than for product export. And one reason would be that the value of such services is more difficult to monitor. And selling services is more personal than selling products, because it quite often requires a direct involvement with the customer. The involvement demands greater cultural sensitivity when services are being provided across national borders. So, in understanding the service trade, you see some prongs what are reserved in cultural elements. As you see later in the employment contract, for example, Japanese culture in the workplace between male and female workers would significantly differ. But promotion opportunities may be restricted. And also some of a work division would be informal, so a female worker would often engage in some chores, serving tea, whatever. And also, that is the point we have long been hesitant to open our legal market, for example. The cultural and also intellectual discrepancies and what a kind of incongruence may factor. In a recent double-tier FTA between United States and Korea, we are required to open the legal market on a staged basis in about its extent. In 4 states, we may allow them to reside, for the natural person to reside and provide a foreign legal advice. And in the second stage, we may open our legal market that the foreign firms may be entitled to branch office in Korean territory. And also Korean authority enacted the statute about a foreign council. So how do they conduct their business in any legal fashion? So the legal requirement and their status in Korean territory were incorporated in basics and guidelines. And also, you see the serious contention between Europe and European Union and the United States about liberalization of a film market in Europe. What is a cultural exception? So there are scope of attributes distinct from transaction of goods also may be proper in consideration of this area of law. You see? So services are much more difficult to standardize than products. Service activities must frequently be tailored to the specific needs of the buyer. This need for adaptation often necessitates the service client's direct participation and cooperation in the service trade. The ability to standardize the services also creates difficulties in measuring and regulating the quality of services. Furthermore, government attempts to regulate services may be viewed as intrusive, given their often personal nature. Free trade in services heightens the concern of less developed states about being overrun by service providers from the developed world with superior technical skills and greater numbers of trained professionals. Conversely, free technical skills and great numbers of trained professionals. Conversely, free trade in services heightens concerns regarding labor and immigration in the developed world, as trade creates greater mobility and resultant migratory labor force. And in many service sectors, the accounting service now have been availed of a fashion of uniformity and also reached a substantial level to universalize the provision of service. So the service sector also be viewed in a distinction about financial you see in typology about classification of services on page 402, construction, design, and engineering, banking and financial services, insurance services, and legal accounting services, computer and data services, and teaching services, management consulting services, and telecommunication services. You see later one case covering the dispute about the insurance contract. It is actually interesting to promote the businesses in global capitalist economy. So, have you ever come across the word advertising injury? Now, the subject matter that the insurance contract may trigger cover. In the last page, 426, 427, you see the case titled "A Heritage Mutual Insurance Company versus Advanced Polymer Technology Incorporation." It is a domestic case disputed in Indiana of the United States and was dealt by a federal court in 2000. Heritage Mutual Insurance Company is an insurer, and Advanced Polymer Technology is insured. And the insurance company has made reasonably required to regulate the terms and conditions of insurance contract. And they made a second adaptation to print their terms and conditions, the form of contract. So, what is the context the case developed? And APT in this case insured and pursues the heritage mutual insurance company is obliged to defend the case in the claims against other impeding parties. In this case, advertising injury is some of a delicate term to or allow an alternative interpretation. So it is a little indefinite to see the exact meaning of this term. In the contract clause, the prescription would be like this. What is that? And an injury arising out of one or more following offenses may be insured. Or first, oral or written publication of material, slanders or libels a person or organization, or disparage a person's organization's goods, products or services. Oral or written publication of material that violates the person's right of privacy. And misappropriation of advertising ideas or style of doing business, or infringement of copyright, title, or slogan. So it is one of a primary sector that the international service providers now operating insurance service. So it is a domestic question, as I suppose. However, it may have potential to be controverted in the international community in any way. So very reformed fashion to be noted involving insurance dispute. So the insurer in Indian law insurer in Indian law is required to prove that the claims fall within the coverage. So prima facie case needs to be established by insurer. However, all other rebuttal and defenses may fall upon insurers. So there is the co-polish to favor the insured against insurer. So the insurer bears the burden of proving specific exclusions or limitations to policy coverage. In this case, the insurance contract may afford the protection about defense of claims from other parties of insured, and also the duty to indemnify the insured. And the cost of to devise a different level of a persuasion between the duty to defend and duty to indemnify. You see, the insurer's duty to defend is broader than its duty to indemnify. When an insurance contract contains, I now on the last case. When an insurance contract contains an ambiguity, it is strictly construed against the insurance company. In this case, Environ, a patent owner, claims that APT willfully infringed on its patents. It also accuses APT of federal unfair competition under the Lanham Act by contending that APT made false and misleading statements as to the creation or ownership of the piping product in its application for a patent. The parties have not contended that the patent application constitutes an advertisement or an item in the course of advertising as required by heritage APT parties. Environ alleges the defendant, APT's marketing of its Polytech piping system as patent pending creates a cloud on its ownership of the invention, thereby discouraging investment in or purchase of its products. APT claims in abbreviated fashion that environmental allegations fall within the disparagement category of advertising injury offenses. Importantly, environ never contends that APT's advertisement mention environment. Compare the products of the respective companies or discredit or denigrate environment's piping products. While we believe that some direct reference to the competitor's product is necessary to fall within the plain meaning of disparity, we also do not view environment's allegations as resulting in a reasonable claim of implied disparagement either. So, the issue in this case matters at the scope of coverage, agreed upon by the parties concerning the term advertising injury. The implication also that the creative economy concept now highly advocated by policymakers of South Korea. So the kind of business operations, interactions may involve some new frontier kind of advertising, which could not be witnessed in previous decades or other decades. And the trade of services, as you introduced the outline on pages, as a kind of aspect against the trade of goods. And the concept also is practical if you see some mixed nature of sale, mixed sale. Often the transaction may incorporate types of subject matters in coverage of goods, services, and also involves a transfer of a technology agreement. And in the class over the weeks, we may see the laws and rules about the license agreement and other types of international contract. Often they may be sectioned in concept. However, practically they come in as all elements. For example, what is a franchise agreement? It allows the franchisee may use the trademark of a franchise. One aspect to involve a license agreement, the technical transfer, and also they sell the goods, which is required in ingredients to maintain the business reputation and integrity. This material should be used for a distinct flavor. This trademark may only enable. Also, the workers, employees in McDonald's or other visible workplaces should bear same uniform and also conduct in a manner to be universal across the global nations. And also that requires the workers to be trained. So we may have a sporadic contact to arrange a training and skills learning program. Also, that program may be implemented. Kind of deals may be incorporated into one piece of a contract, franchise agreement. And when you think about the service trade, most importantly, we need to share hiring a foreign person. It involves manpower, labor element, as you see. And that is most a troubling point that the U.S. business persons need to address. So jumble of different laws and a strict requirement of rules and laws, often omnipresent across global jurisdictions, as you see. And it often leads to some of exorbitant overhead costs. So one of central concern to prioritize their business in terms of profit, you see. So the principle in U.S. employment labor law is the employment at will doctrine, you see. So it is actually free and submissive to traditional motion of freedom contract. It is a concept to sell their goods to the buyer. So I now sell my labor force to the employer. That is all. So the employer at any time may dismiss the worker's employer at his will. So it is one of starting point we consider. However, that is not the case oftentimes in seeing the international businesses. So, for example, Germany now has the Termination of Protection Act, and works councils now are responsible to protect the workers in accordance with the statutory mandate. And also, the French Labor Code has some extent of devices, an apparatus to facilitate the public moral about a labor arrangement. The covenant also be stuck and prevalent involving two communist nations, the Russian Labor Code and also the Labor Code of the People's Republic of China. So, first of all, we see some of a threshold issue to frame the venture involving the labor in the international business. What type of a hiring a foreign personnel would most adequately address the business needs in specific forms or enterprise. So we see, for example, a foreign sales representative with an agent and disputes represents a services or sells goods on behalf of a foreign sellers. And also we see some of a usual pattern in practice involving agency arrangement. Often the contract is titled agency contract, what is, when we see in comparison the distribution agreement. So what's the nature of a specific agreement is the issue we need to be careful about. So in some cases, that often requires a mandate to represent the principal, and the agent role may apply to case. So fiduciary duty, and also some of obligations, legal obligations to disclose the fact on the street, and also the kind of duty to be confidential about the trade secrets and others. And the compensation method would also differ depending on what the nature of contract is. Okay? The agent contract often be remunerated on what a commission, as you see. So how many transactions could be completed or agreed upon. That is the basis to calculate your compensation. However, that is not the case oftentimes about the distribution agreement. So the foreign suppliers in determinative nature sell the product to the foreign distributor. So the profit and compensation would accrue from the margin between the selling and purchasing prices. So that is also the idea the Korean commercial law relies on. So you see in the series and rules in high exposure in your commercial class. So I waive the point. And also interesting is that the cultural element would lead to some odd consequences if we are innocent about the context of a specific nation. So you see in the box some information about standard sexual harassment policy. So in some worse consequence, the principal may be involved, which forces to compensate a extended cover tort damages or contractual remedies in amount merely because about lack of knowledge concerning sexual harassment policy. And also it is pivotal to comply with employees' code conduct, ethics code, what it called, should also allow us some ideas to deal with labor issues. Yeah? What is rude or discourteous behavior? Theft or personal dishonesty, use or possession of alcohol or controlled substance on company premises, maintenance of inappropriate files on the company's internal network, transmission of confidential information of email system, disclosing non-public information, including a trade secret, duplicating a software products, engaging in any act of harassment or discrimination. And it is wiser for the business manager to utilize an independent contractor in the purpose to avoid the strict requirement of labor laws. So that is the point, practically useful. However, in some cases it may be condemned in the same context of employment, notably in France. So the French authority may catch all the arrangement which is highly vulnerable to the workers. Independent contractor may be shamed in some context. And the context was also conformed in some extent about the previous occasion of a financial crisis in Korea. So many dismissed employees were hired on the basis of independent contract relationship. That is only a device to avoid the legal requirement, labor laws. So, some commentators may say the kind of a disguised arrangement, which takes essentially the nature of a employment contract. How to consider? In any case, in concept, that have a different notion and often mandates a different interaction between employers and employees. And so it is termed equal as a matter of law. However, practically may not be perceived in that sense or in effect. And I also mentioned the types of agreement what reserved in agency contract. So, for example, Meshpano recognized 3 different types of representatives. In the mediation contract, the mediator does not represent the principal, but rather distributes the information about the principal and its products to potential purchasers. In the commission contract, the requirements come in different mandates. So you see, the representative receives a mandate from the principal to accomplish a given task in return for the payment of compensation, usually in the form of commission. The term agency is reserved for the commission agent, whose contract with the principal serves as general power of attorney with respect to commercial acts. In addition, in some foreign legal systems, this relationship is subject to a significant amount of statute control. And I've illustrated the Japanese case and some equality concern in workplace between male and female workers, and also some national initiative to restore the social justice in the workplace. You see some of achievement in Japan. In 1985, Japan adopted the Equal Employment Opportunity Law. However, this law is very astonished to ascertain dominantly the previous pattern of a workplace practice. So it was subject to public criticism, and a new law was made in 2000. So it prescribes the harassment of a female worker. So the right of a woman to work in a harassment-free environment was ensured in statute ambit, you see. And this new law entered force in that year, took an effect. And the new law also defines the scope of harassment and creates procedures for employers to follow to address the problem. Given these differences across the global relations, the U.S. company should tailor, of course, we are more familiar with the Japanese culture, I suppose, modifies the existing policy to take into account different cultural and legal standards of a sexual harassment. And in terms of a business strategy, how can such modifications be justified? That is the serious question to be delved in advancing the business into international play. Culturally and legally, the employment relationship is viewed differently throughout the world, as I said. So, the employment law actually exposes kind of scope of differences we often encounter. And the first area is the employment contract itself. And the next concern would be the term of employment, and also some more mandatory act or statute to protect the workers. Civil law countries in Europe do not recognize the Avil doctrine and require written employment agreement. So often civil law countries are generous about the formality of contract, you see. And with the writing requirement, usually in the context of a statute of fraud, as on tradition in common law system, involving a labor contract, the civil law country is required to be written in order for the contract to be valid. So it reflects important aspects of relationship, such as parties, the work to be performed, salary and benefits, vacation, starting date, place of performance, and notification periods. The same general requirements are applicable in France and Italy, pursuant to their respective labor codes. The writing requirement is not unique to Western Europe. For example, the labor code of Russian Federation and the labor code of People's Republic of China now practice a same fashion in terms of writing requirement. In some aspect, it may be strengthened and elevated to be the public code. So what is the second topic of comparison? As you see on page 4 or 10, term of employment. The laws of many countries discourage a temporary employment agreement. For example, Germany in Germany, temporary employment agreements are permitted for a period not to exceed 2 years. Employers seeking to utilize such agreement in excess of 2 years must demonstrate good cause for the deviation from German law. So we have long been toiled and so that the policymakers have been troubled about the casualized workforce or a contingent workers, kind of. So how do you consider the nature of their labor? And in Italy, fixed terms of employment set forth in contracts are valid in very limited circumstances. Temporary employment contract must be in writing and may be extended only once for a period not exceeding the original term. The extension must commence at the time of expiration of the original term, must be for the identical job performed during the original term, and must be with the employee's consent. Any failure to conform to these requirements converts the relationship into permanent employment contract. Temporary employment is similarly limited in the Russian labor code. However, by contrast, China's labor code recognizes the term of the employment agreement may be fixed, flexible, or set according to a certain amount of work to be fulfilled. So the arrangement is a diversion to meet a specific tiers. So leeways to advance our business into mainland China. And you see two notable achievements or may be obstacle for the free enterprises, the Termination Protection Act in Germany and French Labor Code. The Termination Protection Act became effective January 2004. Nevertheless, the ability employers to terminate the employment relationship remains severely limited. In the absence of behavior detrimental to the interest of the employer, employees of works with more than 10 employees can be terminated only if termination is socially justified. So the wisdom through the code would be staged from the beginning of contract, and also the aspect of termination, and also some of compensation mandated to be paid to support a social cause. You see, that context would be seen in a French labor code. Let's see, what are redundancies? It generally is the equivalent of dismissal on, based on economic reasons. So there are a scope of reasons to dismissal, and you see previously led to the ethics code of employees, and some unethical conduct and other breach of what the social value others. You see theft of personal dishonesty, duplicating software products, many culpable causes often be leveled to the criminal context of a consideration. And other causes typically sensitized would be redundancies, layoffs based on economic reasons, and you may encounter some of a public opinion about the French labor relations, often in Korean newspapers. How do you consider if it is upholdable in consideration of our national economic status, well developed, and often be covered in a different? How do you see? And you see, in the French Labor Code, there are legal provision about mandatory notice. For example, the employers need to offer ample opportunities to transfer to another workplace in others, and also some of affordable compensation to fill the gap because of that job transfer. And also there are many learning programs to support the technical or skills requirement in order to facilitate labor mobility. And also the point noteworthy it would be the dispute settlement system. Often these nations institute some of a special course in Consulting, and also the work councils in Germany, and labor code, of course. And in French context, termination is valid for cause. Cause exists where the employee's action constitutes such a dereliction of duty as to undermine the very root of fiduciary relationship between the parties. Termination may also be justified if it is for a subjective justified reason. Sorry, this point would pertain to the case of Italy. The standard requires a serious breach by the employer of the employment contract. And termination may be justified if there is an objective justified reason. This reason relates to redundancies arising from the employer's business operations. To avail of this reason, the employer must demonstrate that there was an objective reason for the redundancy directly connected to economic factors, and the terminated employee could not be redeployed because of the absence of a suitable alternative position. Complaints alleging wrongful dismissal are resolved through alternative dispute resolution. So in Italy, you see also the special court system, arbitration courts, and specialized labor court. And in the manner of regulation, the policymakers often consider the size of firms and how many workers are employed in this business unit, and in some cases, workplace in its entirety, or in Germany, you see some of a minute concept about business unit and 10 or 15 workers, 5 workers in some cases. And also, on pages, you are exposed to the international labor standards. And also the concept perhaps would be in conflict with a WTO commitment. You see, it is the organization in pursuit of ideas of a trade liberalization, and or in some antipathetic notion, the International Labour Organization may require the legal commitment about protection of workers. However, the concept would be in such dualism. We have some also tendency about increasing commitment of the United States and other developed countries. Notably, the worst illustration would be child or prison labor, which exploits the workforce in a very humane manner. So that also is a concern of the international covenant about protection of basic human rights. You see two notable declarations about political liberal rights and also social rights in the context of the United States. And a labor issue would pertain to the international standard of social rights. However, it is also challenging to obligate all the member states into one level of a labor standard. They have be on track on different economic status, and also may be marginalized in some cases that you see in the African states, fighting hunger, what is. So that could vary. However, that is a new agenda which WTO is reluctant to incorporate in its whole uniform fashion. So it a diversion. And it is ambitious that the United States enacted the institution about this concern. Section 1307 of Tariff Act of 1970 prohibits the importation of goods produced with prison or indentured labor. And in 1996, Section 1307 was amended to include goods produced by using forced or indentured labor, including labor provided by children. So the labor issue also in interplay with international trade. So in some cases, it offers the basis to ban the importation in its entirety. That is closed Polish objective to the violation of intellectual property, United States intellectual property. Right. However, the implementation would be sporadic, and long has been a public issue for debate in the United States why it should be sporadic. Some continued and systemic way implementation need to be assured. And the EU has addressed labor standards on a piecemeal basis by incorporating them into agreements on specific activities. And it as the attribute of human rights protection, the issue also be considered in terms of a preferred status in tariff rate. As I say, in GSP system, we have the group of developing countries afforded a preferred status tariff rate. However, this anomaly may disqualify their privilege to that preferred rate in some cases. U.S. directives require the insertion of labor clause in public procurement contracts. And also, we have another pro-labor device recognized in Europe, the Works Council, as discussed earlier. And in 1993, Uber Europe announced the closing of plants in France, resulting in the loss of 700 existing jobs. Partially in response to the public outcry, the EU approved the European Works Council directive that requires large companies, mostly multinational corporations, to establish European Work Councils. That directive is estimated to cover about 1,500 multinational companies operating in Europe. And even in stalemate, the ILO now ambitious to announce ILO Declaration of Fundamental Principles and Rights at Work. It has enumerated a number of core labor standards. What are those? First, a freedom of association and the right to collective bargaining. Elimination of all forms of forced or compulsory labor. Abolition of child labor. Elimination of discrimination with respect to employment and occupation. So labor issue is fairly advanced in contemporary society, however, would come least in consideration where the force to liberalize trade is most powerful, actually. And a new agenda now explored by WTO30 would cover, as I've said earlier, the anti-corruption and environmental issues, and also competition problem. What is fair? The justice in viewing the fair competition would differ and should be put on the table to be debated and exchange the ideas for international justice, and also maybe instituted in definite terms into the WTO covenant. And you now need to know the points important about the international commercial agents contract. So legal questions that should be considered in negotiating a termination clause in an agent's contract. This is a focal point that national policymakers would often share. What is the content included in the contract to terminate by the foreign capitals? So fair justice in international trade, another concept about antitrust, anti-cartel. So first point, how far in advance must the representative be notified of the exporter's intention to terminate the agreement? What is just cause for terminating a representative? Which country's laws will govern a contract dispute? So laws in the representative country may forbid the representative from waiving its nation's legal jurisdiction. What compensation is due the representative on dismissal? What must the representative give up if dismissed? The contract should specify the return of patent, trademarks, name, registrations, customer records, and promotional materials. So, notably, you see the practices in dominant fashion about a grant back clause. The technology and skills invented during the terms of contract should be granted to the licensor. Or how about the technology developed by licensing? Is it mandate obligatory to transfer the technology to the licensee? Should the representative be referred to an agency? The contract may need to specify that the representative is not a legal agent with power of attorney. In what language should the contract be drafted? English should be the official language of contract in most cases. It is dominant practice. And 3 months satisfies the requirements of most contracts. Often, about the period of notice. And specifying causes for termination in the written contract usually strengthens the exporter's position. Laws in the representative country may forbid the representative from waiving its nation's legal jurisdiction. And in the box, titled Focus on Transactions, you see the ICC Commercial Agents Guide. And you begin with the independent contract status, definitions, identity and capacity of parties, products, and duty to keep informed, for example, and what the context of intellectual property rights intervene to affect the legal, the relationship between the agent and principal. So it is helpful to refer to in understanding this class discussion. So, any questions? Then that'll be all for this class. See you next class.